Hello, everyone, and welcome. Thank you all for joining Foley and Lardner for our 2021 Virtual Labor and Employment Summit, Transitioning Back to Work. And now I will turn it over to Larry Perlman to introduce today's presenters.
Hey, good morning, everyone, and thank you for the introduction. I am Larry Perlman. I'm a labor and employment attorney in Foley's Miami office. My partners and good friends, Carrie Hoffman and John Litchfield, are here with me today. Carrie's in Dallas and John's in Chicago. Along with numerous other attorneys in our labor and employment and our other practice group teams, the three of us in varying degrees work in the firm's COVID-19 task force. That means that in addition to counseling clients on COVID-19, we publish and edit those updates that you hopefully get from us and get from us frequently. We also internally debate, digest, and come to consensus on all the sorts of issues we're going to discuss today. I should correct and say we try our best to come to consensus because you know how us attorneys are, right? So let's first figure out how to move my slides because that's the toughest part. Okay, great. Let's go back in time a bit first. I don't want to go all the way back to February 2020, the pre-pandemic America, at least for purposes of this presentation. I'm talking about going back just 90 days to June of this year. The pandemic was seemingly on the decline. The vaccine curve was on the rise. We all saw a light at the end of the long tunnel. You all got your personal invitations telling you to come to the Foley Employment Summit in Chicago. We were going to be on stage at the House of Blues. We were even going to have a big reception, as the invitation said, because we were back. We were all ready to meet up in person, talk about the best ways of getting back to normal. And imagine we were even ready to talk about a variety of non-COVID related topics. This would have been our first in-person summit since 2019. And speaking of 2019, if you look on the lower left, there's Carrie, there's me on stage at the House of Blues, along with our partner, Dan Kaplan. And just in case you weren't there, the upper right photo, that's a real 100% true and accurate picture of the crowd, all our attendees at the last summit, just showing how amazing of an event that it was. Right? We played the House of Blues. So how it turned out, we're clearly not in the House of Blues this morning. Many of us are not in Chicago. We're not all together, at least physically. Instead, we're back to that life of a remote video conference that we've become so accustomed to. I'm not going to belabor why. The Delta variant has taken hold. Cases, hospitalizations, and deaths, unfortunately, have been in the upswing the last few months. And safety considerations raise sufficient concern over having a multi-person live indoor event. We had to postpone. There's nothing here you don't already know, but I do think it was valuable to recount this process to highlight the fact that the three of us and our colleagues, the problems we help you solve, those are the identical problems that we face ourselves, right? And just our, decision making over this summit reflects that. Beyond that, remote working, accommodation requests, what to do about vaccinations, whether or not to have in-person events. We don't just counsel on those issues. We live and we grapple with those issues too. Let's talk some good news. As disruptive as the pandemic has been, imagine if it was 20 years ago or 10 years ago. The type of virtual meeting we're having this morning, it just wouldn't have been possible. But now we indeed can do this. So what's this, right? What's a roadmap of the next almost hour and a half? Part one, we're going to talk about mandates. Most topically, President Biden made some serious moves on September 9th. We're going to devote attention to what we know, what we don't know. But even before that, there were a number of existing mandates and sources of guidance. We'll remind you of those, and we'll talk about vaccines in general. Part two, accommodations. I assume y'all know that for every mandate or company rule, there's the exception of unless a disability or religious accommodation is applicable or warranted or appropriate. We'll talk about those, what you have to do, what you don't have to do, and we'll go through some hypotheticals on topic. Then part three, some of the nitty-gritty of managing all this. There's too much to cover everything, but we're going to talk about a couple of topics of particular important interest. One, incentives. A lot have already been offering or considering offering incentives to have a workforce vaccinated. And it's something that you're going to continue to think about or address, even if vaccine mandates apply to you. Number two, the be-all, end-all question of much of this, who pays for all of this, right? Quick housekeeping note, as was already mentioned briefly, as you can likely tell already, I talk a lot. I like to talk a lot. You'll see that John and Carrie are big talkers too. When we get together, forget about it, right? But so what we need you to do is be a check on us, help us keep things moving, keep things real. Throughout the presentation, if you have questions, put them in the chat box. If we see them, we'll answer them or we'll circle back to them later. And at the end of each individual session, we're going to invite you to unmute yourselves, show your faces if you want, and just ask us questions directly, and we'll go ahead and answer them. With that, let's go to part one, vaccine mandates. We internally, meaning John, Carrie, and I, debated the order of this section. Should we go chronologically, for example, what's happened since last March? Ultimately, though, the truth is, for the past 2 weeks, most of us have all been asking and answering an extraordinary amount of questions about President Biden's path out of the pandemic announcement on September 9th. So we figured, let's tackle that head on and first. We all know that the White House's announcement on September 9th of a 6-point plan to combat COVID-19 made quite the splash. If you can see in the small print, the New York Times in a banner-wide headline proclaimed Biden issues sweeping mandates for shots. Multiple news reports said vaccines mandatory for 100 million Americans. Not quite accurate, which we'll get into in a moment. This is the United States of America in 2021. So, of course, there was no unanimity of reaction. Some, like the editorial on the right, welcomed the announcement. Others, like the crowd in Times Square, referenced in the article on the bottom, were, let's say, not quite as enthusiastic. But regardless of how we feel about these actions, regardless of political or personal philosophy, I do think the Wall Street Journal hit the nail on the head for those of us sitting here today. The headline was, "Companies Grapple with Questions About COVID-19 Mandate." There sure are a number of questions out there. Companies are grappling, so let's go forward and grapple with those questions, right? What exactly did the president announce on September 19th? In broad strokes, there are 6 prongs to the plan. 1, large employers. This is the one that has received the most publicity because it affects the most individuals. All employers of 100 or more are going to have to require vaccines or weekly COVID testing. OSHA is going to come up with emergency regulations to put this into effect. Number 2, if you're a federal government contractor or subcontractor, you may have to require vaccinations. Number 3, if you employ healthcare workers, they'll probably have to be vaccinated. Those first 3 prongs are the most germane by far to those of us sitting here today for these purposes. Just to round it out, though, 3 more. Certain federal government employees are going to have to get vaccinated. I don't believe we have anyone attending from the federal government who fits that bill, but indeed that's out there, executive branch employees, vaccine mandate. Number 5, fines for masks on public transportation, or more appropriately for not wearing masks on public transportation, are being doubled. And number 6, which does dovetail with some of the considerations that you have in terms of implementing all this, the government is taking steps to make testing more available and more affordable. Let's make sure we're all on the same page as to what exactly the September 9th activities involved. Despite what much of the lay press has put out there, the plan is not one single mandate. In fact, it's not in many ways a mandate at all. There is no absolute government requirement that Americans get vaccinated. There's no power to come into people's houses, give them an injection and say, well, if you say no, too bad, there are consequences. It is not a get out of jail free card. You don't get to say, well, I don't have to worry about accommodations anymore because we have this federal government mandate. And it is mostly not final yet in terms of what you have to do and not have to do. In contrast, here's what it is. It's a multi-pronged series of mandates and executive orders aimed at increasing vaccination. It exercises government authority through several agencies and arms of the federal government. But what it does, it largely puts the burden on all of you. It puts the burden on employers to carry out the stated goal of increasing vaccination rates, meaning that it's something that we all have to understand and take seriously. Let's start with large employers. I see there was already a question about large employers, which I'll get to in a moment. This is the part of the presentation where if we actually were at the House of Blues, I'd be saying, okay, raise your hand if your company, if your business has more than 100 employers. I know for a fact, based on who's attending, that a good amount of you would be raising your hands. Basically, OSHA has been directed to issue an emergency temporary standard, or what's called an ETS, to require all employers of 100 or more to ensure vaccination or weekly testing of employees. An ETS is a rather rare phenomenon. Before last spring, when OSHA issued an ETS for healthcare workers based on COVID-19, the last ETS had been in the early 80s, I believe. When you talk about an ETS, the temporary is important, emergency temporary standard, because as opposed to regular OSHA action, the rule will be implemented, the standard, before a notice and comment period, and it will have an expiration date. So what happens is standards issued, and then we're going to have the opportunity to comment. But while that commenting is going on, the standard's in place, and there's an expiration in 6 months, at which point, or shortly before, OSHA decides whether to extend or not. What's going to be happening in 6 months from now with respect to pandemic, I'm not going to try to predict because every time I have tried, I'm not an epidemiologist. Even the epidemiologists have, modified their predictions over time. Again, this is the second ETS for the pandemic. First was applicable to healthcare workers, was not vaccine focused, but we do get some guidance from there. A lot is unknown about the ETS that has not yet been issued, right? I told you the basics of what the White House announced. There's not much more than that out there now. What we do know, the next day, September 10th, OSHA held a briefing. It was led by Ann Rosenthal, senior advisor to the agency. She gave a little more guidance. One thing, and this is a question that I saw come across my screen that I've been asked before, although not 100% certain, it is likely, and Ann Rosenthal from OSHA said this, that the ETS will not apply to remote workers as long as those workers are completely remote. If they occasionally come in the office, if their expectations to show up for meetings, sometimes they're in the workplace and it will indeed apply. But for true remote workers, it likely will not apply. And that would be consistent with the healthcare ETS, which excluded providers of telehealth services. Some other things that we don't know or have minimal knowledge, how do you count to 100? And who is an employer of 100 people? Well, what we do know, at least from the briefing on September 10th, is that it is not a location-specific requirement. So you can't say, great, at our facility in Madison, we have 75 people, but in Sheboygan, we have 50 and we have 10 at Cleveland, so we don't have to worry. No, it's the aggregate of your company. The phrase enterprise was used. So you are going to, if you have more than 100 people, it will apply, right? And it's going to apply, as far as we can tell. I saw another question come up. Whether or not you travel is not the rate limiting factor. It's whether or not you're coming into a workplace versus completely telecommuting. But in terms of counting to 100, we know that you have to have only 100 total employees. There hasn't been guidance as to, how do you count temporary workers? How do you count, intermittent workforce, a workforce that waxes and wanes? Is it going to be an average of 100 over a period of time? Does it apply the moment you hit 100? Those are some questions that are out there, along with what does testing mean? What tests will be acceptable for purposes of the ETS? How are these data points expected to be recorded and reported, which are significant issues for OSHA? Who pays for the testing? Who pays for the vaccines? Previous ETS guidance suggests that there probably will be some requirements, at least for employers covering costs of compliance, including possibly paid time off provisions to get vaccinated, for example. We also don't know when it will be released or effective. That the conventional wisdom as of September 9th was somewhere from 2 to 8 weeks. We're already in that 2-week period. So it certainly may be coming soon. When the healthcare ETS was issued, there was phased compliance in terms of, when do you have to follow certain mandates in the ETS. For some factors, there were only 2 weeks given. There was only 2 weeks given to comply. So you aren't going to have very long when the ETS is released, or at least we should assume you're not going to have very long. And the other issue, we don't know for sure the cost of non-compliance. Advisor Rosenthal on September 10th said that she expects if you, as an employer, violate, you will be charged with a serious or willful violation under OSHA. For those who have been fortunate enough not to have faced OSHA violations before, that means approximately $13,000 to $136,000 per violation. And what's out there is, what is a single violation, right? Is it on a per employee basis? Is it on a policy basis? There's a lot here in the stay tuned category. Next. I just want to make sure. Next prong, federal contractors. This is a dense bucket of slides. I am not going to go through every piece of the language in these slides, but basically, President Biden issued an executive order that speaks to federal government contracts and subcontracts. In a very technical sense, there is no vaccine mandate in the executive order. What there is a requirement that new contract language be developed and be inserted into contracts for renewal, for going forward, and for new government contracts. We fully expect, especially given the way this was rolled out, that there will be vaccine mandates as part of the new contract clauses, but not 100% from a technical point of view. We're going to have to see what these contract clauses include. Guidance on those contract terms is going to be provided by the Safe Federal Workplace Task Force. I have not seen it come across yet. The date that the task force is supposed to provide relevant definitions and explanations is tomorrow, September 24th. So we anticipate that a number of unknowns will be answered, but the requirements will start to take effect by October 8th or October 15th, depending on what type of contract. So again, there's not much time. This next slide is a laundry list of who these requirements will apply to. I will not go through all of them, but what I note in particular is that the contracting requirements apply to any workforce location in which an individual is working or is working on or in connection with a contract. In connection with a contract. That is broad language. And while not entirely specified, it appears to indicate that as opposed to the ETS for the 100 or more employees, you don't necessarily have to be a worker on site. You have to be part of the team. And in fact, if the if the existing executive order on federal employees, item 4 of the 6 points, the one I said we're not going to discuss, provides any guidance, the federal contractor requirements may even apply to teleworkers. The federal employee one explicitly does. And there's authority for the government to say, if you want to contract with us, all your employees, who fit within certain criteria have to be vaccinated, regardless of whether or not they're remote working or not. So again, we can expect to see a different scheme, a different universe in which the contracting requirements fit as compared to the 100 or more large employer requirements. Again, there are a variety of exclusions, and there are going to be a variety of exclusions. Most importantly, if you're a government subcontractor and you solely provide products, not services, the requirement is going to be inapplicable. Again, there are many nuances here, and this is a particular area where we suggest consulting with counsel at a threshold to determine coverage status and go from there. Next, healthcare. Point 3, while this does not apply to everyone in today's meeting, significant enough number of attendees are indeed healthcare entities or entities saying, well, are we a healthcare entity and covered, that it bears some attention. So real quick, this part of the 6-point plan applies to those who receive Medicaid or Medicare reimbursement. If you receive reimbursement via Medicaid or Medicare, you're going to have to require that your staff are vaccinated. CMS, which is the Center for Medicaid and Medicare Services, will be issuing a final rule in October, but the intention is that it will cover a very wide array of locations comprising healthcare. Notably, it is likely to include all sorts of staff, not just those providing direct patient care. And we know this in part because that was the case with an earlier requirement for nursing homes. So next steps. With all this, to the extent that you're covered or strongly believe you're covered, act now. If you don't know if you're covered, take steps to find out now. Do not wait for the courts to come to your rescue. As you may have read, as you may have seen, as we're keenly following, there are a number of legal challenges pending based on a variety of legal theories. But unless and until those actions or those parts of the 6-point plan are enjoined by a court, you're going to have to comply if covered. Next, don't wait for the final rules or orders. Obviously, in the past 5-10 minutes, there are many places where I said, stay tuned, more guidance is coming. But the logistics of all this takes time. And you need to at least start or be close to complete soon and coming up with your policies, your procedures. It does not happen overnight. If you don't have such policies, if you don't have vaccination requirements or vaccination and testing requirements in place, it takes time to figure out how this is all going to work. Perhaps most importantly, you need to staff appropriately. You are going to have to devote people power to carrying this all out. And on the flip side, you may need to staff or figure out how you're going to staff in the contingency that people in the workforce leave because they do not want to follow these mandates or they have objections on different bases. There are, one of the theories of this sweeping national scope was that folks who may be apt to leave because of a mandate or a testing or a vaccination mandate would say, well, there aren't many places for me to go because so many others, potential employers, are going to impose the same requirements. But this is not a universal, all United States series of events. Smaller employers will not be covered who are not contractors or not in healthcare. And we know because our clients have been struggling with the idea of what if people leave, something to think about, plan ahead for, and take other steps, including some of the incentive materials we'll discuss in a bit. Additionally, it's important to remember we and the government divide the executive actions into 6 prongs. You may be covered by multiple sources of authority. Let's say you provide healthcare services, but two members of the federal government or via federal contract, you're large, you have more than 100 employees, and you take Medicare and Medicaid for payment, you have to make sure you comply with all. And there are all sorts of combinations of those requirements. Additionally, as we'll get into in a moment, any and all prior requirements, state laws, local laws, mandates are going to apply too. Those mask mandates, OSHA reporting issues that applied before, they don't go away because of these new actions. So a lot to keep in mind. With that, I'm going to turn the slide deck over to Carrie Hoffman, who's going to talk some more about vaccines.
So let's take the step back and talking about big picture, what it means to force our employees into compliance with mandates, but we need to look at what these vaccines are and what they look like. So from that standpoint, here's where we are today. The Moderna vaccine and the Johnson & Johnson still are under emergency use authorization. Only Pfizer has full FDA approval. I'm sure if you all are dealing with vaccine mandates in your workforce, you're dealing with a lot of that pushback about what FDA emergency approval looks like versus what full approval looks like. And only Moderna has approval for use in children and only ages 12 and up. So again, we've gotten a lot of pushback from employees over what all of that looks like. As you probably read last week, the FDA approved boosters for the Pfizer vaccine, but only for ages 65 and up. I can speak that my parents got their boosters way long ago, way before they were approved. And so there's a lot of that going on. A lot of obligation about providing time off for symptoms related to boosters, and that, people with weakened immune systems may also be eligible for boosters. But how are we dealing with those issues in the workplace on a daily basis as we attempt to comply with all of the things that Larry was talking about? So facts have made the vaccines controversial. If you had said to me in 2020, as I was preparing, didn't get to go on spring break, that I would spend this much time talking about vaccines, I would have laughed in your face. But these issues have made vaccines controversial. Employees are saying things to their employers, my kids can't be vaccinated, so why should I bother? If we can't prevent it in my family, why does it matter to me? There was fetal tissue used in making the vaccine, and that violates my religious beliefs, and I'm not going to take that type of vaccine. The vaccine inserts a tracking device into me so the government can figure out everything I'm doing, when, how, why, etc. And then the other one that's a very popular response is, I've been vaccinated, but it's none of your business, and I'm not going to provide you my vaccination card. My health concerns are my health concerns, and you don't get to delve into the details. Everything about the vaccine has become political, and we're very divided as a country. And the answers really don't matter much, meaning the reason they refuse isn't relevant unless we have to deal with accommodating religious beliefs or medical beliefs. My children can't be vaccinated, so why should I? Not really our problem as we navigate through whatever part of the mandate may or may not apply. From our perspective, I'm sorry about the dog barking. I'm in the office, so I'm not clear what that's from. But big picture, we have an obligation to figure out what we're going to do as far as mandating. Even if you're not covered by the president's order, you're entitled to mandate vaccination if you choose to do so, unless it involves medical or religious reasons. So I can say as of the end of August, about 25% of the United States population that's eligible to be vaccinated is not vaccinated. And that currently we have 3 approvals. As I indicated, only Pfizer has full FDA approval, and it hasn't seemed to change most individuals' minds about whether they should or shouldn't be vaccinated. For those of you who got vaccinated early on, you took what you took and you didn't throw a fit about it. Now you can walk into almost any drugstore and likely ask which vaccines they're providing and take your pick. So if you only wanted Pfizer because it's the only one with FDA approval, you could likely get there, again, depending on age range and the like. But my answer is, let's not make a debate about these subjects with employees. We need to make a decision about what we're going to do with respect to mandating and or weekly testing if the president's executive order applies, and then move forward and have the employees deal with those issues as they come up. So again, we've had a lot of challenges even before the executive order came out about mandating vaccinations. Obviously, as we've touched on and are going to get into more detail as we work through this material, we have an obligation to accommodate medical conditions and religious beliefs. And that's become a very popular way of avoiding it. And then the other issue, as we're going to get into in a lot more detail, is the remote work issue, which is pre-pandemic. If you had said that everybody could shift to working from home, with the exception of people who drive trucks and work on assembly lines and those types of positions, we would never have believed that people could successfully navigate work remotely on a full-time basis. But we had to adjust based on where we were from a pandemic standpoint, and let a lot of people whose positions didn't seem like they would fit do so and work from home. And that's changed the way we have to deal with accommodating those issues. And we're going to get into a lot more detail in that. And then the other challenges we've had is it's very easy to find a fake vaccination card online. I don't believe when the government issued those vaccination cards early on in the pandemic that anyone thought they would become and would need to be something that we would be able to regulate in a much more formal fashion than we are currently able to do. I will say, according to the FTC's website, it is illegal to create a fake vaccination card and use it for anything. Ironically, you have to pay for a fake vaccination card, and the vaccine itself is free. So it's ironic that what effort people will go to. Then there are privacy issues about the vaccine. We'll get into more detail about that. But again, a lot of misconception about whether this is HIPAA obligations, whether it's ADA obligations with respect to who's vaccinated, who's not, what masking is required, how do we deal with all of that? And then who pays? When we have time off related to the vaccine, when we have time off related to COVID, what are we obligated to do? So we're going to cover all of these burning topics. And again, big picture, it's not been an easy world to navigate. And then I'm going to turn the presentation over to John Litchfield from our Chicago office. John?
Thanks, Carrie, and thanks, Larry. And I should note, we're particularly lucky with this group today because Larry's humble, but in a past life, he actually was a practicing physician. And so a lot of these issues are really great. And Larry has been helpful for our entire practice group in answering some of the medical questions, which we'll get into sort of in detail as we talk about accommodations and other issues that may come up. But I thought that was an important point to make because Larry wasn't going to make that on his own. But at any rate, so I'm going to talk a little bit about state-specific issues, as Carrie mentioned, with respect to vaccines. As we've been talking about from a federal perspective, it's fairly clear that from a federal law perspective, that private employers can impose vaccine mandates on its workforce, and some of them will have to, given the new ETS that's expected in the next couple of weeks, obviously with some minor limitations. But what's interesting is that several states are considering or have enacted regulations that will either limit or completely ban, in the case of Montana, an employer's ability to impose vaccine mandates on their employees, on their workforce in those jurisdictions. Obviously, some of this will be, ferreted out in the courts as time goes on. But it's important for employers in particular to take note not only of what is currently the law, but what may be coming down the pipeline as certain states enact different regulations. For example, let's go through this real quick. The slides are moving, right? Okay. So the big picture issues that we're facing right now is that only Montana has a complete ban on employers outright imposing vaccine mandates. And that means that any employers with employees in that state can't mandate vaccines for those particular employees under current state law. We don't know exactly where that's going to go with respect to the ETS and how it may address some federalism issues that may come up. There will definitely be litigation around Montana's ban, but it is something to note for employers that have employees in Montana. As I noted a second ago, other states are considering bans on employer vaccine mandates. This is mostly outside the context of healthcare, elder care, or education. So employers outside of those industries, you should be on the lookout for particular bans that may come into play in the coming weeks and months on vaccinations for workforces. And then other states are actually considering extending exemptions rather than an outright ban. So, for example, Arizona, like Montana, has a vaccine mandate ban that is being considered by the state legislature that would basically be as broad as Montana's sort of outright ban. It hasn't passed the state legislature yet. The governor hasn't indicated whether or not he'll sign it. But it is important to pay attention to Arizona and some other states that are considering Montana-like bans. Then there's states like Idaho, which is a little bit more scaled back, and basically what it says is that any private employer that is contracting with the state can't require their employees that are working on that contract to be vaccinated. They can't have a vaccine mandate for those particular employees. So that is something that employers will want to pay attention to. Again, it is not law yet. It is something that is at least being considered by the state legislature. And then, I'm sorry, I just lost the slides. I don't know what happened to those. Okay, thanks. But Indiana is considering a measure that would essentially prohibit employers from requiring immunizations if the employee is medically contraindicated, or if that immunization, and they're not specific to COVID, it's a broad requirement, but if that immunization is against the employee's religious belief or quote unquote conscience. And we'll get to conscious objections a little bit later in the presentation, because there is a bit of a conundrum that employers will face on that subject. Thanks, appreciate it, Carrie. All right. On the flip side, some other states are sort of going in the complete opposite direction, and they're issuing their own mandates for certain sectors of the economy. For example, right here in Illinois, I sit in the Chicago office. Governor Pritzker issued Executive Order 2021-22, which I think has a nice sort of rhythm to it. But it mandates all healthcare workers, school personnel, and university personnel to prove that they had their first jab by last week, by September 16th. And if they didn't do that, then they'll be excluded from the workplace until they do get their first jab. And in fact, they have to be fully vaccinated within 30 days after their first jab, or 30 days within from the date that the imposition came into place. So by October 16th, all personnel that fit within those categories of workers will have to be fully vaccinated in order to be given access to their work site. As you know, healthcare workers have to be physically present in order to do their job. This extends to people in elder care, and it includes most employees. It's not just those that are performing direct healthcare services, but it's those who are interacting with other individuals who are providing healthcare services. So back office staff, front office staff, billers, to the extent that they're in the office. So the definition of healthcare worker under this executive order is quite broad. It's intended to really push individuals in these industries to be fully vaccinated. Now, the state does allow under this executive order, like many others across the country, for religious and medical exemptions, although I'll call them accommodation requests. We'll get into that a little bit later. But it does allow for those particular exemptions. However, an employee who has either of those exemptions that they set forth to their employer has to undergo at least weekly testing in order to be permitted on site. If they don't conform with either the vaccination requirement or the testing requirement, then they will be excluded from being physically present to perform whatever job duties they're expected to perform. So that's something that's particularly important to pay attention to. I think it's important to look at the details of the executive orders and the laws that are being passed. California has a similar mandate for healthcare workers that is slightly different than Illinois because it doesn't necessarily allow for accommodations for religious objections, although I think most of our California colleagues would say that their clients or those with folks who are in California are going through that interactive process for religious objections. And then Delaware has a similar law where long-term care workers are required to be vaccinated by September 30th. This is just a sampling of states that are coming up with either executive orders or agency orders. California's, is through their healthcare, the public health state agency, and then some legislatures are actually considering similar type of mandates. What's important to note, though, is that with no good deed comes the lack of punishment. I bring up the concept of sort of the conundrum that some employers will face in certain states and in certain industries as these mandates come online, whether they're state mandates or federal mandates. For example, in Illinois, we have a bill called, or a law called the Healthcare Right of Conscience Act. There are other states that have similar laws on the books, but essentially what this says is it's a law that was passed in 1997, sort of outside the context of a pandemic, but what it says is that employees of healthcare providers have the right to object to performing certain procedures that they find morally or religiously objectionable, that impact their conscience or their moral convictions. In a couple of contexts, we've seen this come up already, where employees are trying to expand sort of what this law was meant to prevent, which is employers performing, or employees, I'm sorry, in the healthcare industry performing certain procedures such as euthanasia or abortions or whatever they might have a moral objection to vaccine mandates. And in an extreme example, we had a client that had an employee say that not only did they not want to comply with the state's executive order regarding the vaccine mandate for healthcare workers, and this particular individual worked in a physical therapy setting, but he also believed that his body was a temple and so therefore would not comply with the testing requirements that the state imposed in order to allow him to do his job. So we've got some employees that are using creative arguments to basically not comply with any vaccine or testing requirements that employers may put forth. It's likely that this particular type of law will not necessarily apply. It certainly doesn't apply outside the healthcare context. It won't necessarily apply to all employees, but we're likely to see some challenges where these laws exist on the books in certain locations. We also may see state legislatures move to amend these laws or to change them in the context of a pandemic. So just more to stay tuned on as things go forward. And we have a moment for some Q&A. We want to take a break because this is the end of our first section. There are some questions in the chat. Larry answered most of them. But if you have a question, one of the sort of dilemmas we have with this virtual format is that we don't have the ability to sort of directly interact with our audience, as you know. And if you've been to the summit in the past, you'll recall that it is a very interactive summit. It's one that we actually enjoy the interaction on. So if you have a burning question, you can either put it in the chat or feel free to unmute yourself for a moment to ask your question. Just be sure to remute yourself so we can avoid the dogs barking in the background. But Larry, the first question that I don't think you necessarily touched on in your presentation from Anita Simmons is for government contractors, and this relates directly to the executive order we talked about earlier. Does it apply to only those on the contract or all employees at the company?
And thanks, John. So with respect to that question, my understanding is, based on what's been put out there, it's going to be on the contract or in connection with the contract, right? Which is clearly a very broad, a broad sampling of individuals, but I do not anticipate that it will be all members of the company necessarily. We're going to have to see what each contract provision includes. I also wanted to point out for the two other series of questions that I partially answered, I wanted to give a little more clarification. I saw them coming through as sort of just blips on my screen. I think one, I misunderstood the question about remote employees who travel on business. Looking at it, I think the question is, what if we have field employees who never come into our office, but they're not really working at home either, right? Like sort of like your outside salespeople who are always on the road is the way I would think about it, or people who just are in an executive capacity and always traveling. While there's not a definitive answer on that one yet, my based on what OSHA has done before, based on what OSHA's requirements are, my prediction is that if you truly never go into a company location, you're not going to be covered. And that's where the delineation is. I say that for a couple of reasons. One, having to do with OSHA's scope of enforcement. And number two, if you look at the healthcare ETS, that applies, it basically says if you're performing telemedicine, the ETS doesn't apply. It doesn't say telehealth, but not if you're sitting in a shared workspace, but not if you're in a different location. It's if you are not at the healthcare facility, right? What's going to get a little tricky is you may come against, and it's an issue we've dealt with in accommodation, your employees being sent out into the field to other spaces that are covered by strict requirements. And if you're not applying requirements to your employees, the third party may say, don't send your salesperson in if they're not vaccinated. So long-winded answer to that short question. The first question I wanted to clarify on the 100 worker requirement. With respect to whether or not you have 100 employees, there's going to be a difference between are you covered by the ETS, by the mandate, and is each individual employee covered, right? So if you have a company that has 150 employees, 90 are purely remote workers, 60 are not remote workers, right? And come into the office, you are going to be covered by the mandate because you have more than 100 employees, regardless of how employees are defined. You have 150, you're covered. However, the 90 employees who never, ever come into the office, they're not going to likely have to be vaccinated or tested, whereas the 60 who do come in are going to be subject, even though you don't have 100 who come in. So I hope that clarifies the answer to those questions. And now I just took all the air out of the, hey, everyone, speak up and talk and join the party. So I hope I didn't stifle that.
I actually have one sort of practical note based on that question regarding, Anita Simmons' question regarding contractors and whether it applies to all employees or just those on the contract. And it's really a practical consideration that I think government contractors will want to consider is whether you want to have two classes of employees, right? So if like Larry says, the executive order only applies to employees on a federal contract, or for example, in states where there may be an executive order that says we're only going to contract with employers that have vaccine mandates. Consider whether it's reasonable or feasible for you to have two classes of employees, those who are vaccinated and work on federal or state contracts and those who are unvaccinated and who don't. Some employers won't find that tenable. It might create morale issues. And so even if there's not a legal requirement to have every single employee in the company vaccinated, there may be a practical consideration you want to think about.
I couldn't agree more. Sorry.
I was going to say, and enforcing that, now I'm moving you to the government contract, so now I all of a sudden have to get you vaccinated. It's going to be difficult, I think, practically speaking, to have two classes of workers.
Yeah. And I think, it's always a carrot and stick kind of analysis, right? And it's going to depend on where you are in your organization, because we know what you have to comply with. There are, as we know, all sorts of different philosophies, both with respect to individuals and corporate philosophy as to, do we want to mandate more than is being required? Or is our corporate philosophy such that we'll do what we absolutely have to, but we, for various considerations, don't want to, we don't have an interest in further mandates? That's a decision that, and discussion beyond the scope of this. But for those employers who want more vaccinations in the workforce, I've heard and I've counseled a number of clients who found this guidance quite welcome in that it puts, literally, we're sorry. We've heard all your complaints. Blame President Biden. There's a lot, coming out here from the federal government. We're going to basically have to, we're going to have to enforce and do more. And y'all saw the news, right? The question came in, just to that, to that effect, which is, can we go further than what the government's requiring? Can we as a company require all employees to be vaccinated and not allowed for testing? Except for those states where, and I think it's just state right now, right, where you can't, require vaccinations, you can go further. These are generally minimum standards. So if your, company's view is, we want everyone to be vaccinated, we're going to forego testing, you can do that with the caveat that you're still going to have to consider accommodations, right? Religious accommodations, disability accommodations, and testing may be a reasonable accommodation, which is what we're going to get into shortly.
Yeah. A lot of good questions coming in. Carrie, I don't know if you want to move ahead, because a lot of these questions will relate to the accommodation section, or if we want to answer them specifically, I'll let you decide since you're up next.
Just to try to keep us on track from a time perspective, I'm going to delve in, and then we can have another Q&A once we get through the accommodation on disability and religious issues, if that's okay with everyone. So moving into part 2, and we'll try to get all those questions answered as we go through. The issue from an Americans with Disabilities Act is the employee entitled to an accommodation under the Act based on a medical condition? That's based both on potentially having had COVID and having symptoms related to COVID, and with respect to vaccines. And so one of the things that happened either late last week or early this was a federal judge in Pennsylvania allowing a former employee who was terminated, she claims, because she'd had COVID and had a disability and was requesting accommodations. She claimed to have long haul issues related to COVID and wanted accommodations, and the company wasn't willing to provide them to her. I think as we have now gone into, the 18-month-ish mark on the pandemic, we're going to start seeing more of those types of cases coming down the pike. And then, of course, what seems to be taking up most of our time these days is vaccines and accommodations related to it. Employees are very easy to find. Sample letters, frankly, if you just Google, I don't want to work in the office and I don't want to be vaccinated, what do I do next? You can find all sorts of great sample letters online of telling employees how to request accommodations and the like. It doesn't matter, if they have a quote unquote diagnosis, they could have a history of reaction to vaccines or an underlying condition they'll claim prevents them from being vaccinated. And of course, all they have to show under the ADA is that they have a physical or mental impairment that substantially limits a major life activity or bodily function. And so from a big picture perspective, a lot of what we're dealing with are those types of issues. Employees claiming they cannot receive it because of a disability-related condition or reason. And so we have to start considering alternatives. And again, we haven't gotten the OSHA ETS. The OSHA ETS for private employers that are bigger than 100 is about mandating vaccinations or weekly testing. And so certainly we can accommodate someone's request if it's a valid request and we have to. So we're going to discuss that issue about unvaccinated employees and whether they potentially pose a direct threat to the health and safety of that employee or others in the workplace as we struggle with whether we're going to be accommodating individuals' requests. But assuming the employee has a disability, what's our next step? Our next step is that the employee, can they perform the essential functions of their job without posing a direct threat to themselves or others? Pre-pandemic, whether someone got a flu vaccine, we would never have considered as an issue. But there are other ways around it. We can test, we can require masking, we can require social distancing, depending on the nature of the job, and remote work. As I touched on earlier, we would never have believed that so many office employees could function remotely in the way that we did, especially at the height of the pandemic in 2020. So from that perspective, we have those issues, and we're going to have to start dealing with ongoing requests for remote work, even when they're not related to COVID, because people frankly like sitting around in their t-shirt and shorts and flip-flops versus putting on real work attire and coming to the office. And so we're seeing a lot of requests about remote work. Of course, we have to consider modification of duties, changes in roles, and we're going to have to continue to be on our tiptoes as we account for changes in the nature of the virus. As Larry said earlier, in the early part of the summer, we were convinced we were done and we were emerging from, and we would no longer be dealing with these kind of issues, and started sort of this transition back to regular, whatever that may look like. And then it didn't work out for us. The Delta variant hit. And so we're going to have to start, again, potentially revisiting accommodation requests in ways we might not have thought we would have to in the past. So when I get a request from an employee, I can't be vaccinated because I have X condition, or I have had COVID and I need to work from home, or as we'll talk about a little bit later, I have underlying medical conditions and I'm more susceptible to COVID and I'm worried about coming in and I don't want to work from the office, I want to work from home. What do? I have to engage in the interactive process. As I tell clients all the time, usually the person who loses this battle is the one who broke down the interactive process. So interact to your heart's content. It's no different from any other disability accommodation request. We have to evaluate that request, discuss accommodation options, and remembering that employees are not entitled to the accommodation they want. Like I said, we're hearing a lot about remote work. We can provide other measures of accommodation that don't involve remote work, distancing, private officing, masking, lots of things can be done, PPE, that don't necessarily involve remote work. But we need to have a valid basis for it, meaning that remote work can be an accommodation and often maybe should be an accommodation. But if you're going to deny it, we need to be prepared to defend it and have other alternatives available. Like I said, not very many people are in the office every day. You may be able to provide private workspaces to individuals who previously, sat in a hallway or in a call center. If they can sit by themselves, they can wear masks, enforcing mask mandates for all of your workers, but having alternatives available. Let them work Monday, Wednesday, Friday from home, Tuesday, Thursday from home, and let them see if they can perform to the satisfaction of their supervisors and the company remotely before you deny that request, because again, they did so successfully in all likelihood for a period of time. And so again, I think we're not going to be able to persuade a lot of courts that in-person attendance is an essential function of the job. It's a little bit different if you have employees who are not available when they should be during their regular work days, times, etc. So big picture, we need to make sure we're holding their feet to their 8 to 5 time clock if that's the hours they're supposed to be working. Obviously, as we've discussed, employees really like the flexibility of remote work, right? I don't have to wash my hair. I don't have to put on real shoes, whatever that issue is. But we're losing a lot of what made people enjoy the place they worked. We're losing camaraderie. It's much more difficult to mentor over the phone and supervise employees over the phone, or frankly, even through this kind of mechanism where we're looking at each other on Zoom or Teams or however we're doing it. But if we're not going to provide that kind of remote work, they're very likely to go a place that will tell them, if nothing else, that they're going to. So we need to be really clear about that and what our expectations are, the hours they have to be available online, where the work's being performed, meaning it could have tax consequences if I'm now working full-time from a state that has a state income tax, unlike the state I'm sitting in Texas. I may have state tax consequences that go about it. I would communicate to employees that it's not permanent and that they may be required to be in person as needed or as requested. And, remind them that things may change if their performance lags, if they're not available when they're supposed to be available. And then the nerdy wage and hour lawyer in me always needs to remind people, for your hourly workers, we need to make sure they're not working unauthorized overtime. So we need to have a method behind the scenes to track whether they're logged on and working when we don't want them to be working if they're not reporting their time accurately. So again, we just need a mechanism in place that makes sure we're dealing with that the way we should be dealing with it. This month, the EEOC, as I indicated earlier, filed a lawsuit in Georgia about a company who denied a remote work request. This employee had worked from home for the months of March through May of 2020, as many of us did. And the employee didn't have COVID. She just claimed that she had other illnesses, lung disease, hypertension, and for whatever reason claimed her condition was vastly better when she was at home in those months and working remotely. So she asked to work remotely 2 days a week, and the company denied that request because they required all their employees to come back to work in June of 2020. That case is pretty new, so we'll see where it goes. But I think that's a sign of the times. It's going to be harder to deny remote work, and we're going to have to start exploring creative options that we would never have contemplated if that hadn't happened. So big picture, we need to be very cognizant of the fact that employees are judging everything we do with respect to that issue of remote work and whether we're going to provide that accommodation even on a temporary basis and hold their feet to the performance fire versus being in the office. And then if not, make sure we've offered alternatives to remote work that will provide them that help. Once we determine that we need to accommodate someone, we can evaluate the direct threat issue as to whether we still have that obligation to accommodate. We've been talking mostly about remote work, but this applies in the vaccine context most clearly. A direct threat is the significant risk of substantial harm to the health or safety of the employee or others that can't be eliminated or reduced by reasonable accommodation. We can't mandate an employee get a vaccine if they can prove it's a direct threat, but conversely, an unvaccinated employee might be a direct threat to others in the work environment, especially in assembly lines where things are, PPE is much more regulated, and whether they can or cannot wear those may have those kinds of issues attached to it. So we need to be very careful that we're going through the analysis on an individual employee basis. We have to decide what's the duration of the risk. At this point, if we could predict the end of the pandemic, we'd all buy lottery tickets and not be talking about it any longer. So who knows how long the risk is for an unvaccinated employee and whether or not they could bring COVID into the work environment. The nature and severity of the potential harm, the likelihood that harm will occur, and the imminence of harm. So we have to look at the whole picture of the work environment. Is it an inside or outside job? What's the ventilation look like? How close do the employees have to work together? All of these things go into the analysis about a direct threat. And again, it's certainly possible in places with high community spread that unvaccinated workers are a direct threat. Although the EEOC in and of itself concedes it is a high standard. I've given you all the link if you want to spend your evening reading about direct threat, as I did last night. But again, it's going to require a very individualized assessment of the issues and what other mitigating measures we can do: masking, distancing, PPE, looking at the percentage of vaccinated workers. Can we put individuals who are susceptible to, because of their disabilities, further away from unvaccinated workers? And again, not putting a scarlet V or not vaccinated on someone's chest, making sure we're looking at all of those issues in making the decision about whether accommodations can be provided or if the individual creates a direct threat. And with that, I believe I am turning it over to John to talk about religious accommodations.
That's right. So let me just flip to the right slide. Thanks, Carrie. So I think probably most of you, like us, I would say, even here at Foley, over the past couple of weeks, couple of months, have seen sort of an uptick, and maybe the most common request for an accommodation is a religious accommodation to any vaccine mandates these days. This is just coming up with such frequency at this point because, I think a large part of ADA accommodations is commonly known to employers. It's easy to deal with. It's something that they, especially large employers, sort of address on a semi-regular basis. But religious accommodations are something new for most employers. And so if you're like the rest of us, you've seen a big uptick in sort of where things stand with Title VII, which is where the religious accommodations issue comes into play, and how to address those. And what Title VII says with respect to religious accommodations is essentially it just prohibits discrimination on the basis of sincerely held religious beliefs. But judicial interpretation of that and the federal regulations have basically said that requirement not to discriminate on the basis of religious beliefs is similar to the ADA in that it requires employers to provide accommodations and go through the interactive process that Carrie talked about earlier to employees who are otherwise qualified for their position but have a belief that conflicts with a particular employer requirement. This has historically come up in the context of dress codes that employers have, grooming codes that employers have, in the context of working hours, religious observances that conflict with regular working hours. And so there just isn't a lot of case law that's out there on religious accommodations to date, although I suspect, unfortunately, and hopefully it's none of you, but we will start seeing some case law developments in the coming years, months, perhaps. But at the very least, religious accommodations are something new for most of us. So what is a definition? What is the definition of a sincerely held religious belief? Well, the federal regs define it as a moral or an ethical belief as to what is right and wrong, which are sincerely held, and the strength of traditional religious views. It's sort of a weird definition. It doesn't really help us. But what the Supreme Court has said is that though a religious belief is something that is not political, it's not sociological, it's not philosophical. So in the context of COVID, people who believe that COVID is a hoax, that's not a religious belief. People who don't believe in the science behind the COVID vaccines, folks who think it was developed too fast, that is not a religious belief. People who just have a personal objection to receiving a vaccine for whatever reason because they don't like being told what to do, that's not a religious belief. And so while the federal definition is a bit loose, and while we tend to err on the side of caution with religious accommodation requests, those types of beliefs are not necessarily religious. So what's important to note as well, particularly when we're dealing with these, is that most major denominations, including the Catholic Church, have urged parishioners to be vaccinated. And this is despite this sort of the very loose links between what the Catholic Church and others generally see as morally objectionable conduct, which is the use of fetal stem cells in research or testing for medicine. There is and Larry can tell us sort of more specifically, but there's a very, very loose and distant link that may exist between that type of research and vaccines. And that's really what people are citing when they are asking for religious accommodations. And despite the fact that most of these major religious denominations have said that this tenuous link is not morally objectionable, in fact, it's a moral imperative to be vaccinated in order to improve the health and safety of the rest of the world and the communities in which we live. People are still refusing for one reason or another. So how do you, as an employer, accommodate a religious belief that is truly something that's difficult to analyze? Unlike a medical or a disability accommodation request, a religious accommodation request is a bit challenging to analyze. You can't send, well, you could, I suppose, send a request to a rabbi or priest, but you can't send an accommodation request to a medical provider and expect sort of scientific or sort of backed up information about why a person can or can't perform the essential duties of their job and what reasonable accommodations they may need in order to do so. So it's a little bit challenging for employers to determine exactly what to do with a religious accommodation request. What's important to note, as Carrie said, the interactive process is exactly what you're going to need to engage in. It's a similar process under the ADA in that you want to get at least some information from the employee about the basis of their belief, when they came into the belief, and exactly what their objection is to receiving a vaccine that is linked to that belief. These are types of requests that are reasonable. They're within the scope of what we would expect employers to get from their employees and what we would expect employees to provide. But note that it's under the ADA, it's an individualized assessment to determine whether or not there may be a reasonable accommodation that an employer can provide. It's the same under a religious accommodation request. You've got to go through the individualized assessment. Unfortunately, there's no one size fits all approach. And so that's something to keep in mind as you're going through this. What's important to note is that some employers, and in most circumstances, you may not want to push back on the sincerity of the belief itself. But what you do want to do is get documentation. We talk about this all the time with our clients: document when you're engaging with employees on particular issues, especially around accommodation requests. Your documentation is your best friend if there's ever a claim that's filed. You're going to want employees, documentation of employees' religious beliefs and these issues that sort of are raised here. And you want a form that you want to develop. We can help you develop forms. We have forms available that are similar to disability accommodation request forms. But the important thing about getting this documented is that employees are making sort of, in our minds, amazing admissions in these documents about sort of what their beliefs are and sort of where they come from, when they came into them. And so that really helps us sort of at least evaluate, number one, whether the stated religious belief is sincerely held. But number two, even assuming that we don't question the sincerity of the belief, if there's ever litigation later about these issues, those accommodation request forms are going to be sort of exhibit A in any cross-examination of a plaintiff that brings a religious discrimination claim. So that's really important to get this documentation. The question about whether you can push back on a sincerely held religious belief or a purportedly sincerely held belief is one that you're going to want to engage counsel on, because this is not something that sort of is common or easy to do. But some questions that may be raised with respect to whether or not a belief is sincerely held is whether the employee has received any other vaccines. A lot of employers, especially in the healthcare and in regulated industry space, not only require immunizations of certain employees, but are expected to do so under certain state or federal regulations. And so if an employee has received a vaccine in the past, then you may want to question whether or not their belief about the COVID vaccines is sincerely held. If you offer flu shots at your office, and you know for a fact that an employee has gone to get a flu shot before, that may be another indicator as to whether or not the belief is sincerely held. And in fact, right now, most employers, including Foley, have folks on site that are administering flu shots, and so it's a good time to sort of keep an eye on that. The other thing that we're seeing, and this is coming up with extreme frequency at this point, is sort of the copy and paste rent a rabbi type of objection, where employees are sending this diatribe of what they state their religious beliefs are. They're citing religious passages. They're citing various state laws or federal laws that they believe, or at least the sort of author of this particular copy paste job believes may help them find a way out of a vaccine mandate. If it's a copy paste job and you can prove that by a quick Google search, you may want to question whether the employee has a sincerely held religious belief. The other one that's come up with at least some regularity amongst our biosciences clients, biotech clients, are individuals who are working in labs that are dealing with the same, similar, or even more closely related technology to fetal stem cell research. or technology that is similar to how, either the mRNA vaccines were developed or the Johnson & Johnson vaccine was developed. And they've never stated an objection to working with those materials or that type of technology in the lab. So that's something that you may want to push back on. So there's instances where you may want to question somebody's sincerity, but I would say by and large, you should believe an employee when they say they have a sincerely held religious belief. So what accommodations should be offered when somebody requests a belief and you've approved it, or sorry, an accommodation for a religious belief and you've approved it? Carrie went over most of those, but a couple other things that you may want to consider. And to be quite frank, as we noted earlier, some states will require in certain industries is testing on a weekly basis. If you want an employee physically in the workplace and they refuse to get a vaccine, and you doubt that it's for a sincerely held religious belief, but you don't necessarily want to question it, you may want to require that they test 2-3 times a week. I know, for instance, at Northwestern University at Kellogg School of Business, they are requiring their students to be tested multiple times a week in order to have access to classrooms. And so I know that's not an employer context, but it is being done in certain contexts, and it's something that you can require. Remote work, again, Carrie talked about that, if it's possible. In some contexts, you may want to say that remote work is possible, but we're going to reduce your pay or your benefits because you can't perform certain duties in the same way or fashion that you would at the office. And so therefore, sure, you can work from home as an accommodation. But in some cases, you may want to explain that they're going to have a reduced take-home pay. Obviously, ongoing masking, distancing, exclusion from in-person meetings, or limits on business travel will be other accommodation possibilities. The next question that we get a lot from our employers is whether employers can refuse a sincerely held religious belief or to accommodate a sincerely held religious belief. And the answer, quite frankly, is yes. And it's easier to do so under the EEOC guidance and under federal jurisprudence than it is under the ADA, because unlike the ADA, that burden that Carrie talked about earlier need only be de minimis and to constitute an undue burden. And so there's many examples where a burden, a particular request for an accommodation from a vaccine mandate will impose a more than a de minimis burden on an employer. Now, a lot of this is based on context and based on the employee's particular position, this is why it's important to engage in that interactive process on an individualized basis. But these are some settings where a request for an accommodation from a vaccine requirement may pose a particular burden on an employer. Healthcare and elder care settings in particular, educational settings where there's students, where teachers and staff are interacting with students who can't get vaccinated because of their age so far. Customer-facing positions where there's more than limited contact. The hospitality industry is a really good example. Hotel workers, restaurant workers, individuals at sporting events. If you want to impose a vaccine mandate and someone requests a religious accommodation, I would say that if they are in customer-facing positions, there's a good argument that they may pose more than a de minimis burden on the employer if, for some reason, they infect a client of yours or a guest. The other example is if an infection would cause economic harm to the employer. As I am not a sports or a football fan. I like baseball, so I didn't mean to say I'm not a sports fan. I'm not a football fan, but I do know for a fact that the NFL has imposed some regulations, or at least proposed regulations on teams forfeiting matches if there are unvaccinated employees or players, and the player is infected with COVID. And that's a huge economic burden on those NFL teams, on the industry as a whole. And so those are certainly what I would argue are more than de minimis types of burdens on employers. So these are just things to keep in mind. It's very contextual with respect to how these accommodations can be denied. But you definitely want to talk through with your legal counsel, either in-house or outside counsel, whether, if you're going to deny a religious accommodation, how to do so appropriately and how to document appropriately.
John, I don't know if you wanted to answer the question that's in the chat about whether you can require documentation from a religious leader.
Yeah, sure. I was just reading that as we were jumping back on. The answer is yes, but the question is, what's it going to do for you? I mean, if the employee has stated that they have this sincerely held religious belief, and they've justified it, to sort of reasonable satisfaction, then the question is whether or not you need it. You need documentation from a religious leader. Some of our clients do want that. They want to have at least the extra sort of layer of confidence knowing that the employee has actually spoken to a religious leader before stating their objection. The challenge with a lot of these are, as I mentioned earlier, sort of the rent a pastor or rent a rabbi type letters that you'll get that are not specific to the employee, that may be sort of perfunctory. I'm sorry. There are also religious leaders or individuals holding themselves out as religious leaders who are charging people to get these letters, or requesting or requiring a donation to their denomination in order to get these letters. So if you do request that kind of a letter, you're going to want to dig in a little bit on who it comes from, and what context it was provided in, just to ensure that you're getting the information that you need, and that, again, whether or not it's important to you to push back on the employee's stated religious objection, that may weigh on that factor one way or another. So it's a good question. It's one that some of our clients are requesting. Others, they just sort of want the religious accommodation request form to be filled out by their employees. We are at a Q&A break, although I note we're sort of short on time. As Larry mentioned, we all like to talk. This is also pretty dense material. But if there's other questions at the moment, you can feel free to unmute yourself or put it in the chat, and then we'll move on to part 3. Okay. I think, yep, I think we're good for now, so I'll turn it back over to Carrie.
So, nuts and bolts, privacy and vaccines, properly storing vaccination records. The first and foremost thing, because I get this question, it feels like 40 times a week, is we're not allowed to collect them because it's HIPAA protected information. It's not HIPAA protected information. HIPAA applies only to patient information and generally doesn't apply to employers. The only information on a person's vaccination card is their name, their date of birth, and what vaccine they received. We do believe, based on EEOC guidance, these are medical information and need to be stored separately from personnel files, and we're not generally providing a list of those vaccinated and those not within the workplace. But after that, we're okay. So who needs to know who is vaccinated? We need to do a big picture. Limited needs to know. HR and supervisors who have the need to enforce whatever policies you have, and masking obligations, whatever that looks like. How are we going to enforce masking only for those not vaccinated? It would require a full-time person walking up and down the halls. If you're requiring masking, my guidance in following what the CDC has told us in July is that everyone should be wearing masks, or no one should be wearing masks. I think it's easier to require and enforce it for all. I know no one likes wearing them. They're unpleasant at best. But big picture, we need to maintain the cards privately in their medical file, whatever form that takes in your work environment, and only those who have a need to know who's been vaccinated should be told. And with that, I believe I'm turning it over to Larry.
Okay, and I am unmuting myself. So we spent a lot of time in this past hour and a half talking about mandates, but there still is a place for incentives, right? Let's say, for example, you have more than 100 employees, you're covered by the ETS, but you say, we really would prefer that people don't go the testing route, and we don't want to mandate vaccinations, but we want to get as many as people vaccinated. Okay, incentives come into play there. If you're not covered by any of the other vaccine mandates but want to encourage vaccination, certainly you're going to it's something you'd think about as incentives. If you don't want to wait, we did a lot of stay tuned this morning. If you say that's great, but I don't know when these when further guidance is coming out, and let's move ahead and increase our vaccination rate. An important point, if you've already rolled out an incentive plan or program, you have to go forward with it, right? Even if you're going to be mandating soon because the government's requiring you to, you don't want to be hit with, for example, what we call a quasi-contract type claim, like a fraudulent inducement claim, where an employee says, wait, I got the vaccine based on a promise that you were going to provide me, a chance to win all this money or extra money or whatever it may be. And that was a promise you didn't intend to honor, and I've been damaged in some way. So, we have to abide by what we've already put out there to, our workforce. There are many types of clever incentives, which are, on this slide here. You may have others, but these are some of the common ones. Of course, there are also negative incentives. The latter two here are more in the way of mandates, but you can, it's a question of whether you want to, but you can make life more difficult. You have to wear a mask if you're not vaccinated. You have to get tested a lot, which is going to be, quite a burden on someone. You can't do all the fun work things that we do, et cetera, right? So there's the carrot and there's the proverbial stick. If you do have, incentives, you are likely to have reluctance, or you may have reluctance beyond just the notion of I don't want vaccines or I can't get vaccines because of my disability or my religious beliefs. Some people, for example, may say they have privacy concerns. Carrie sort of covered this. But the EEOC has made it clear that in the incentive space, you can require showing proof of vaccination, either for incentives or otherwise. But although not HIPAA covered, this is considered medical information, has to be kept separately. I know Carrie just answered a question on that. Next, when you have a lottery or a contest, right? You say, great, vaccine incentive lottery, you may win a lot of money. You often want to publish the winners' names and be proud and say, hey, John Litchfield from our Chicago office won the, $10,000 vaccine incentive. That gives you credibility. No, you didn't really win, John, sorry. Shows that you actually lived up to your promises. And it gets, a sort of excitement and all that good stuff. But doing that means that you're disclosing vaccine status, which is confidential information. So if you want to publicize either within or outside the company, you want to get consent, optimally in advance while folks are opting into the lottery. But either way, before publicizing names, you need people to say it's okay to do that. Another consideration is whether or not to include those with disability or religious bases for not being vaccinated in the incentive. Is it a reasonable accommodation to let folks, be eligible for the vaccine? Is it discrimination not to have folks be eligible for the vaccine? That's a gray area that we're not going to finish in the next minute of official time. On the one hand, you're facially not offering the same incentives as to the non-disabled or non-religious employees. On the other hand, employees can't satisfy the bona fide business requirement of the incentive program. And honestly, even if they did, in most cases, unless you're given depending on what types of incentives you're all giving, the damages may not be all that high if you take that risk, right? One of the more confusing areas is how much of an incentive can we give? The EEOC has put out guidance saying in its FAQ saying not much. And here's the language. Say, the incentive must not be so substantial as to be coercive. According to the EEOC, that's because you're coercing people into disclosing private health information, potentially conditions that don't let them get a vaccine when the incentive is really high, right? It's, wait, you're giving this big incentive, but then you're going to come and ask me, can you get a vaccine? And I'm going to say, no, I have this health condition, and you're intruding into my personal health information. So a lot of employees look at that EEOC guidance and say, you know what, forget it. No one's going to change their mind on vaccination for a $5 Starbucks gift card. It's not worth it. But let's stop there for a second. Not so high as to be coercive. Isn't the whole point, if you're going to have a vaccine incentive, that you want to coerce employees to be vaccinated? I mean, let's be honest. That's why you're doing it. You're saying, we really want you to get vaccinated. That's why we're offering this. And you actually may be able to do so because the EEOC goes on in its FAQs and it says the limitation on coercive incentives does not apply It does not apply if someone else is doing the vaccinating. They don't say it exactly like that. They say if the employer is not administering the vaccine, you can have a much higher incentive. Presumably, that's because of the point I just made, which is if you're going to the health department to get vaccinated, I, the employer, am not asking before putting a needle in your arm, hey, what conditions do you have? What may make you not have a vaccine, right? So the point is, if you want to give a big incentive, John Litchfield's $10,000, don't administer the shots yourself. Don't contract to have, don't have your agents, your independent contractors in the ordinary course do it. Have people come in, show their card. I went out and got vaccinated. You're not involved. Finally, there are a couple of other common questions about incentives. One is, can you offer incentives for family members to get vaccinated? You actually can. The answer is yes, but, however, that but has to do with GINA, the Genetic Information Non-Discrimination Act. As with the coercion issue, whether you can offer incentives depends on who gives the shot. If you, as the employer, as the company, is giving family members the shots, you may be asking questions that reveal conditions that these family members have, which would give you information, and I know this is attenuated, but it's what the EEOC says about the employee's genetic conditions. And if you have a third party administer vaccines or just have people show proof, no such concerns. Finally, I know we're over, but this is important. If your incentive is a lottery or a raffle or some sort of, contest where you may get a lot, but you may get nothing, you have to be very careful based on what state you're in, because many states have onerous laws on running games of chance. And if you're not set up correctly, this may require opening the contest to everyone, not just those receiving the vaccine, which is kind of beside the point, right? Opening, it might depend on whether or not you're opening to those employed by you or not. Thank goodness for the fine print that you see, honestly, in a lot of, different types of contests offered out there to the public. It may depend on whether you're offering to consumers, again, just your workforce. You may be required to file a bond to cover expected winnings over a certain dollar amount to make sure you pay up. You may even need to file a notice of lottery with the state if the aggregate prizes are over a certain amount. Again, it's oh my God, is it even worth it to do this? There might be disclaimer language required. It's an area where it has been done, it can be done, but you really want to consider these issues and make sure you're doing it right and not inadvertently becoming the Powerball rather than an employer. I'm going to turn it back. I know we're over on time, but I think John had a little bit more. Let's see if folks are willing to stay around and listen. We're willing to talk a little bit more.
I hope you'll listen to me. I'm not
do
sure
I.
anybody really does, but you know how that goes, Larry. At any rate, so the last topic that we wanted to talk on was testing and vaccine pay, because these questions are coming up more and more frequently now, particularly with respect to folks who are requesting accommodations. And so these are common questions that we're seeing, right? Who pays for tests? Who pays for vaccines? Are tests mandatory as an accommodation to a vaccine? Are tests available on site, et cetera, et cetera? And the questions really sort of come down to a couple of different key points. And the first is, are you requiring your employees to submit to testing on a semi-regular basis, right? And that may be all employees. It may also be, or it may alternatively be those who have requested an accommodation to a vaccine mandate. In either case, we do recommend that, although it's not required, that employers do pay for the tests. And part of that is, number one, it cuts down on the potential for employee fraud or other sort of mismanagement of information, even if it's not intentional. And so it really gives the employer some level of control over the type of test that's being performed. Although anecdotally, I had a client reach out recently because the employee had a religious objection to nasal swabs, but was willing to submit to saliva testing. I'm not sure why there's a distinction there from a religious perspective, but it is what it is. In any event, keeping control of the type of test that employers are performing is important. In states like Illinois, PCR tests for healthcare providers are recommended by the state, although they're not required. Because of that recommendation, we encourage employers to pay for the tests. I know it's expensive, but it is something to consider. In most locations, you don't have to pay for the test, so you can send your employees out to do whatever test they find reasonable in order to come back on the work site. But it's something to just keep in mind. The other piece to this is if you're sending employees out to a clinic, or if they're able to go on their own to obtain tests or whatever the case may be, the question for non-exempt employees is, are they entitled to compensation for the time spent traveling to and from the testing site to have their test completed? I think the answer is probably yes, although it's not exactly defined by the regulations that have come out yet, and it certainly is a best practice. That's another reason why employers, we encourage employers to pay for their own tests and have them administered on site or at least close to the physical work location, because it cuts down on that potential for overtime that may exist otherwise, or at least the compensation for travel time. The question about who pays for vaccines is more specific, right? So most large group health insurers will pay for vaccines at this point. So there's no question about sort of who pays. It'll be the insurer. And even under the government, the ETS mandate, there is at least some level of ongoing sort of belief that there will be, ongoing federal support for paid vaccinations. So at this stage, there really isn't too much of a question about who pays for vaccines. It's not the employer, it's the insurer in most cases. And in other cases, it may be the state or it may be the feds. To the extent that an employee is unable to get a free vaccine or is charged for the administration of the vaccine, even if the vaccine itself is free, again, we do encourage employers to cover that cost. It improves the likelihood of an employee complying with a vaccine mandate, even if there is no mandate. It improves the likelihood of an employee just going out and getting a vaccine on their own. And so it is something that we encourage employers to do, even if it's not 100% required under any particular regulation or statute. So these are some of the issues that we see frequently on testing and vaccine pay. It is important just to keep these things in mind, but otherwise, we are at time. There is one more CLE code. Actually, we have two hypotheticals, I guess, that we were going to go through. But Carrie, I don't know if you want to pause for questions real quick, and then we can get into these hypos.
I think that makes more sense.
Okay.
So anybody with a Q&A, feel free to pop on. And John will answer.
I'll do my best. Or I'll deflect to one of you two.
Understood. Doesn't
All right.
look like we have anybody popping on, so.
No question. So do you want to go through your hypo, Carrie, and then
Sure.
Larry and I will bat around some ideas?
Yep. So big picture, Jane Doe report, she's got fill in the blank medical condition, not important. Because of it, she can't be vaccinated and therefore requests to be exempted from a mandatory vaccine policy. She's an assembly line worker, therefore has to work within proximity to coworkers. Does the company have to accommodate her and allow her to work unvaccinated? And so big picture, remote work's not available. There have to be ways to attempt to accommodate her. PPE, masking, again, enforcing masking. I know everyone hates them. Working to make some mechanism available, potentially moving her for different places and the like, to maybe around people who are also unvaccinated, or putting her in a place where she's less likely to infect other people. And does she pose a direct threat? Meaning, is it not possible to wear PPE or mask based on the job and safety requirements that have nothing to do with COVID? If she poses a direct threat and we make that determination because she's likely to infect other employees, vaccinated or not, we may have to terminate her employment. It obviously has risk associated with it, and those kind of claims are likely to keep coming down the pike. The answer likely changes if she's an office employee who's been working remotely since 2020, meaning why would we force her to do this if she's been working remotely? The question we get from
Carrie,
clients a lot is that, yeah, go ahead.
I was going to interject and say one of the things that the remote work, potential remote work issue, office employee issue, and whether you're in close contact with those in the assembly line highlights is the need to, in this sort of not post-COVID, but post dealing with COVID for 18 months world, where people have been telecommuting, it may really behoove you to go over your job descriptions and reevaluate them, and especially for new folks coming in, because the idea of in-person attendance being important is something that we don't always put in job descriptions, but it's critically important in cases where you're arguing with the court over essential job functions, right? And one of the things courts look at, and there's authority over all circuits, is in-person attendance on a written job description. It's not dispositive, not be-all, end-all, but important source of evidence as to whether or not you really need to be in person. And I dovetail that with the notion of if you're foreseeing that there are going to be COVID safety issues, I'd argue you put right in the job description, this job involves close contact with other individuals in close working spaces because of the need to collaborate on whatever it may be. That again gets you credibility in saying, no. We can't separate you. It's not enough that you don't do X, Y, and Z. You need to be close to people. So look back at those job descriptions because they're going to help us help you in the future if people do try to challenge.
To add on to that, and this is another job description point, it's also just a point to consider is, some employees are going to be required to go on site at some of your customers, right? Whether they're salespeople, whether they're maintenance or operations people. And so including what those customers' requirements are for being on site is something that's important. And if vaccines are required by your customers to allow any of their vendors on site, you may be required to ensure that those employees that are going on site are vaccinated, and there may not be an accommodation that's available to them because that's what they do. That's their job, is going on site to perform operations management or sales. And if there's no reasonable alternative available, another inside sales position or perhaps a customer that doesn't have those requirements, then you won't be required to make that accommodation in most cases.
And then I appreciate that from both of y'all. The last point I wanted to make was the issue of she's now requesting remote work in September of 2021 because she can't be vaccinated under your new policy, but she's been a substandard performer since the pandemic hit and working remotely. And that's where these issues are no different from any other performance issue. Waiting until she's thrown her disability on the table is always going to catch you. And needing to have conversations with employees about substandard performance unrelated to these kind of issues as they're happening is the best way to defend from that, because denying her remote work based on her substandard performance when we haven't been dealing with it because it's easier not to is not the way to go. And with that, I'll turn it over to the last hypothetical.
Yeah, and I don't want to spend a lot of time on it because we're about 15 minutes over now, but it's essentially a similar hypothetical, right? But a religious accommodation. The individual's job, he works for an EMT company, he is a first responder, and the question is, does the employer have to accommodate this person for stating that he has a religious objection to a vaccine mandate? And so, when you consider the factors that we talked about earlier, remote work is not an option for this particular employee. They are an EMT emergency responder. They can't do that from home. So that's not an option. They provide direct patient service. They're interacting with patients as they transport them from the on-site treatment location to a hospital or to a clinic. Is mandatory testing possible or desirable in this circumstance? If they refuse a vaccine, that comes into the burden question, and also the direct threat question, which is, does this particular employee pose a direct threat to patients if they're interacting with them in sort of a time of need and they're not vaccinated? Is it even reasonable to offer testing as an alternative? And then, of course, you want to consider state and local laws that may impact that analysis. We talked a little bit about the body as a temple concept. The person refuses both testing and vaccines. I think in this circumstance, you can use the sort of undue burden and direct threat analogies pretty reasonably. It doesn't mean that there won't be a claim that's invited, but it certainly gives you some good defenses. And of course, to Carrie's point in the last slide, if Joe Blow is asymptomatic and infects a patient because he doesn't know that he's infected, and your alternative to the vaccine mandate was mandatory testing, and he doesn't test either, then what's your liability on that front? And really more, maybe in some cases, more importantly, what is the publicity liability, even if it's not a legal liability? So just some additional things to think about. With that, we are actually at the end of our presentation. We went a couple minutes over, but it looks to me like a critical mass of you actually stuck with us, so we appreciate it. And of course, next year, we do very much hope that we can see you in person, and that the Foley band will be able to entertain all of us while we're enjoying cocktails and socializing, ideally without masks, at the next employment summit. So with that, if there's any questions, we're happy to stick around for a few minutes to answer them. Otherwise, we very much appreciate your attention today, your continuing partnership with us at Foley. We are proud to have you as clients. We're always excited to work with you in any context, and we look forward to seeing you in person, hopefully in the near future.